Ladies and gentlemen, dear colleagues, my experience as a teacher tells me that students usually skip the history of legal institutes because it is boring to them. I agree with them. But we have to know the history in order to understand the present and probably to predict the future. The deliberation on most of legal institutes means to confront or at least to think deep into the legal history, to dig persistently into first beginnings in order to detect the origin, changes, and various influences. When thinking about children's rights during the challenging research, I was aware that times were dark and cloudy for most of the children during several thousand years. Furthermore, I was convinced that children hardly survived because of the cruelty of adult persons, as we are now. Their journey through timeline and history was long, dangerous, although relatively short, less than 18 years for each child, so uncertain to become adult that I may state that Homo sapiens is a very resistant and tough species. As a brief overview will show, children carried civilizations on their backs like little titans, paving the way to the better times of which we are contemporaries. The course of history was slow and painstaking for children, unfortunately. I have identified several periods during the history of mankind who attract attention in a sense of a total absence of children's protection or rights, over the very shy indications of some rights, and finally coming to the new era, the era of children. Of course, history is like a river. You can't strictly fix when one period ends and the other begins. In the pre-ancient barbaric times that lasted for thousands of years without any written records, the care for children was aimed to ensure children's living conditions. I'm sure, despite that children survived because of biology. It is the intrinsic mother's and father's love, although nobody is mentioning the love as a base. In that times, many children did not live long enough to reach adulthood, owing to different social reasons as poverty, food shortages, diseases, wars, etc. The question is still in the air. Why, at a certain point of time, in a certain culture and geographical area, children were considered worthy of protection? Within a framework of a child as a value, we can speak about children's legal positions only and mainly versus their parents. Let us start a short journey through legal history. In the Code of Hammurabi, children were viewed as the property of their parents and the means of retaliation. For instance, if a son attacks his father, his hands shall be hewn off. Early legal sources are extremely rare. However, one should mention the Ten Commandments that speak about children's duty to respect their parents, honoring parents by their children, death penalty for children who strike father or mother. But also, the Exodus tells us about the protection of orphans. The New Testament paints a much gentler picture through the call of Jesus Christ on the value of children. We all remember his words, "Let the children come to me." Greek legal history, fragmented into separate city-states with their own legal orders, may be observed through the two segments shown by Aristotle. The concept of philia, a cohesive factor of the family, an unconditional feeling of parental giving, and on the other hand, paternal authority, giving a man a position of a head of the family, ruling over his children like a king, including his right to dispose of the lives of his children. Roman law left more written traces on legal relations within the family, including that of a parent-child relationship. The development of private ownership influenced the creation of the patriarchal family without pronounced male domination, including that one that the father is over all other family members. Thus, under Roman law, the father's rights prevails over his duties. The Roman pater familias possessed lifelong patria potestas, and in the early historical age, almost absolute power over his children and further offspring. Within this legal relationship of patria potestas, pater familias possessed jus vitae agnesis, jus vendendi, and jus vindicandi, legitimizing his power over his children and third parties. Jus vitae agnesis, the right of life and death, has weakened over time and finally abolished in the Christian age in the 4th century, so that, similar to today, every killing of a child was considered murder. The insight into other parts of patria potestas is manifestly the basis of different rights parents have today to protect their children against third persons. To conclude this part of legal history, children's rights did not exist under the Roman legal order, and children were considered as personae alieni iuris. The Roman father exercised patriam potestatem in his interest, not in that of the children. The early Middle Ages were characterized by the particularity of law according to tribal membership. Thus we know more or less about Lex Romana Visigotorum, Lex Visigotorum, Lex Burgundionum, Lex Gundobada, Lex Salica, German, and so on and so on. German or Teutonic law was in the 5th to 9th century, probably, was under the strong influence of the Patriarchate in following 3 previous orders based on Roman law, and in some cases by religious determinants. For succession purposes, distinction was introduced between legitimate or full-born and illegitimate children. Commentators of medieval law found rare legislative forms that were preceded by customary law linked to morality. These are mainly collections of Teutonic law or leges barbarorum, written in Latin with an abundance of Germanic elements, predominantly oriented towards criminal law and relations, rural community, the position of the king, court proceedings, and to a lesser extent the family, more precisely the marriage, and similar relationships. There were absolutely no indications about the rights of children. Feudalism, which developed subsequently and was influenced by the Roman Catholic Church and canon law, relied in the legal sense of many institutions of the Roman legal order, but prohibited infanticide, abortion, and child abandonment. In that sense, one can consider that these the legal beginnings of the child's right to life. However, such rights were certainly not guaranteed for the protection of children, but only because murder was treated as a mortal sin. Another reason for the protection of children was non-religious, in the sense of their right to be born. They could become part of the workforce, and in this context, one encounters exploitative and authoritarian upbringing. The Middle Ages are quite dark with respect to child-adult relationships, including, of course, child-parent relationship. Researchers disagree about the position of children in that period. Some think that children were treated like adults because of their generally short lifespan. The others considered that there was a strong distinction between the mentality of children and adults. Some of them affirmed that children have gradually acquired more and more rights. The other, according to the so-called psychogenic theory of social change, indicate that the evolution of the parent-child relationship constitutes an independent source of historical change. Christian philosophers, as St. Thomas of Aquinas, refers to the epistle to the Colossians. Children, obey your parents in everything, explaining the words in everything as the field of the father's rights. Consequently, the philosophical thought of Christian scholasticism of the 13th century rested on the father's domination over his children. Martin Luther denies parents' ownership of their children, saying that children belong to God. I agree with him. Our view of the West offers the 1641 Massachusetts Body of Liberties, but I'm short with time. I don't want to bother you with this Body of Liberties. The age of enlightenment in the 17th and 18th century in European cultural history was marked by different influences and interpretations of the world. It was opposed to the theocentric world view. It related on the freedom of the human being and their dignity, and did not advocate subordination to authority. In that sense, of course, I can talk a lot about John Locke, Jean-Jacques Rousseau, William Blackstone, and so on, but these philosophers, altogether, I would say, they say that children and adults are endowed with natural rights. This is important, which must be protected. Parents should prepare the child for freedom, since it is God's will, as children are not the property of their parents, but of God again. The first public pamphlet on children, titled The Rights of Infants, it's the French Revolution, 1797, was written by Thomas Spence. He emphasized protecting children from poverty and exploitation and advocated for the elimination of distinction between legitimate and illegitimate children. The French Revolution almost completely silenced the exchange of ideas on children. Very interesting. Until the mid-19th century. In this most radical period, attempts were made to put legitimate and illegitimate children on an equal footing and to expand education. However, the Napoleonic Code halted these efforts, and they were ignored for the next 50 years. After the Paris Commune, attempts were made in France to establish a league for the protection of children's rights. 19th century was a very turbulent era for children, unfortunately. Legal systems during the bourgeois revolution and the industrial revolution were characterized by only a formal equality of all subjects and ignored children. Oliver Twist is a well-known literary character, or maybe a real boy, who can depict how children lived in 19th century. I'm sure nobody would return in 19th century here. Under paternal authority, as workers without rules for minimum employment age, their healthcare or night work. Child labor is a dominant mark of that time and one of the forms of exploitation of children because of their subordinate position. Until the beginning of the Industrial Revolution in the 18th century, child labor was not recognized as undesirable or harmful. That was a normal thing. Moreover, the view of cultural anthropology and sociology on the status of children indicates that the child had the role of a helper in a community or in the family in which it lived. Feudal societies were agrarian, and therefore child labor was focused on helping in farm work and preparing for future independent work in adulthood. Very slowly, civil codes evolved towards greater protection of children and, to some extent, recognition of equal care of the father and the mother under the name of parental authority. In some cases, legislative authorities allowed courts to intervene in cases of impaired relationships within the family. A transition from the 19th century to the 20th century may be seen as an awakening for children's rights through the efforts of some enthusiastic, such as Janusz Korczak. His real name was Henrik Goldschmidt, towards children's rights that align completely with present-day views on children. Liberal paternalism was rooted in parental obligation to teach, guide, train, restrain, temper, correct, admonish, prevent, impose, and combat children. And children have the right to respect, as he says, the right to live in the present, the right to be him or herself, the right to make mistakes, this is interesting for children, the right to be taken seriously, the right to resist education and influence that conflicts with his or her own beliefs. I will now skip over the details about the capitalism, who strives to raise capital and thus increasingly engages children in the work process, even more than the past times. The atmosphere in 19th century is related to children's work. Children were engaged in the work process due to poverty, which was the principal cause of child labor, and a clear link between child labor and forced labor. In some European countries, just shiny, modest and slow changes in legislation aimed at protection for very young children workers, their wages, ban on night work, and under the age of 9 years. I can't imagine the child with 9-10 years that he works today. Improvement of their living conditions, etc. The fight against child labor was marked by advocacy for children's education that necessarily resulted in a reduction of children in the workforce. The International Labour Organization has been focused on child labor since its inception. So in 1919, there were first two conventions about children work. In the normative sense, the 20th century is the century of children. Many states adopted documents on children's rights that are less known to the professional public, thereby contributing to the idea of the need to establish comprehensive global protection of children through the recognition of child-specific rights and their protection. I have found charters or declarations of this type in early years in different countries such as United States, Japan, Arab countries, Israel, Mozambique, etc. In the early 20th century, in the early 20th century, sorry, I'll come back, I hope. Yes. In the early 20th century, recognition of children's rights was unsystematic and modest. International protection of children was a part of protecting person, as for instance, Geneva Slavery Convention. The first acts of international law devoted to the child were conventions on the prohibition of trade in women and children. The horrors of World War I and the problem of hunger in Greece and Soviet Russia left its mark on many children. This has encouraged some individuals and NGOs to launch an international children's movement as Save the Children Fund and the International Save the Children Union. After World War II, the issue of child rights was focused on protection of children and youth from economic and social exploitation. In this sense, the International Covenant on Economic, Social, Cultural Rights provided for the first time that some types of child labor should be punishable by law, for instance, about mortality, health, life-threatening, and so on and so on. States are also required to prescribe the minimum age under which paid child labor is prohibited. There are two important declarations forming a cornerstone on global level. The first one is Geneva Declaration of the Rights of the Child, adopted within the League of Nations 100 years ago, and the UN Declaration on the Rights of the Child from 1959. Both of them were a reaction to social circumstances, so they highlighted the principles related to child well-being and did not constitute rights that would belong to children. They served as guidelines for public policy. The Geneva Declaration, equipped with only 5 articles, makes more references to the duties of society towards children rather than towards the latest rights, and emphasizes the child's material rights. Besides, the declaration announces the later concept of the best interest of the child. The expression "the best humanity can give," we find in Geneva Declaration, implies the future recognizing the children's needs as their rights. The UN Declaration, Geneva Declaration, consists of a preamble and 10 principles. It is a step further in offering a more comprehensive and universal protection of children and their rights, announcing the recognition of children's rights as a special category of human rights. For the first time in history, the Declaration proclaims freedoms and rights of children for the sake of achieving both their interests and those of society together. Albeit a non-binding document, a declaration was an inevitable step towards a Convention on the Rights of the Child. Finally, I would like to say the timeline has shown that millions of children did not survive because of the cruelty of adults. In legal point of view, the lack of legal regulation could not offer them the opportunity to fight for their social position, to be protected against whom? Adult persons. Still, some of them survived, and all of us present here we are the offspring of those children who were lucky to survive. Their victim has watered the garden of humanity that has survived thanks to children, although they have been neglected and considered somewhat less worthy than adults throughout human history. Since Historia est magistra vitae, today we own them the opportunity to live in safe surroundings, to enjoy their rights with legal protection. Legal analysis of 20th century different declarations and conventions are a good indicator of how the concept of children's rights slowly but surely progress together with the consolidation of human rights and awareness of the dignity of human beings, including children, as a dependent and threatened category of species humana. Thank you very much.